We've got a quorum present. This is the October 18th, 2018 Board of Health meeting. Just a reminder, everybody out there, that this meeting is being recorded by audio and video. Not that I see anybody. Is anybody out there that has anything to talk about that is not on the agenda? Seeing nothing, we'll move on. Review of the minutes. Everybody get a chance to take a look at it?
So just one thing on the minutes. The posted agenda says August 16th, the one that was posted online, but the minutes that were the agenda that was printed out and the agenda that was posted in the hallways in front of the town clerk said September 20th, which is the correct minutes. The correct minutes are September 20th. So for some reason, we didn't get to update the electronic version.
I move approval of the minutes.
Second.
Second.
All in favor?
Aye.
Okay, do you want to director's report?
Yep, just a quick 3 bullet points. We're looking to start the venison donation program on November 20th, which is the beginning of shotgun season. Right now they're on the archery season, but we've never really received a lot of donations through the archery season. However, the other reason for us pushing it back is we had originally lost the location to do the butchering, and then we were approached recently with the location, so we had to push it back a little bit. So we figured shotgun season was a good time to start, and we'll be
Where's the
getting.
location?
I'm sorry.
Where's the location?
So it's Marco Banion's old scallop shanty, which has a walk-in cooler and it's a commercial. It's basically set up as a commercial kitchen. So he's been really nice at letting us use that. And then the other 3, tick-borne disease update. We had a very mild summer. Mild season for tick-borne illnesses. That's good news, but also because the summer season the warm climate has crept into the fall, we're still reminding people to be vigilant. Ticks are still active. Usually they're a little they're starting to become dormant at around this time, and they were looking for that last blood meal towards the end of September, early October. This year, we're seeing tick activity well into October, so we're telling people to stay vigilant. And then lastly, we're receiving a significant amount of permit applications this year. The construction boom is showing no signs of slowing down, even with the rise in interest rates and property value. So we're receiving about 10 to 12 plan reviews a week. And right now I'm the only one doing the building plan reviews. And those 10 to 12 plan reviews are just for the building. Then we're also receiving about 2 or 3 septic plan reviews a week, which Artel is trying to keep up with, on top of all of our other inspections and all the paperwork that goes with that. So it's been a really busy season. We're glad to see. And then Hank started again on Monday for the rest of the winter season, and he'll be out on December 15th. So we're really happy to see that. And that's really it.
Good.
A question. Last town meeting approved this concept that sewers under town roads would have to go to town meeting.
Yes.
Will that affect us in any way? I was just thinking about that. If it would delay a year, perhaps, for an approval. No?
Yeah.
I mean, would we be forced into letting people put in septics and not sewers?
Yeah, Jem is a little more.
So we had at our select board meeting last night, we reviewed all the articles that had passed or not passed, and with special attention to Article 3 of the special town meeting 2. As you may, if you were there, you know that.
Unfortunately, I had another engagement.
And if any of you were there, you notice that the council for the citizen added an amendment, a very lengthy kind of legal document, which actually didn't have many changes. But anyway, cut to the chase. So the new wording said that the town would need to go to town meeting for the maintenance and operation of a sewer. Had stricken the word installation. in the amendment of the citizen article. So in fact, it's town council's, now it's open to obviously dispute, but it's town council's position that that does not affect any of the current processes for the turning over of developer installed and accepted by the town sewer systems. Now, he gave a very potential of if you have a, and I can't repeat it because it was very technical potential, but in the face of for the purpose of it, it didn't really it didn't serve the original purpose that was laid out in the article. And the proponent was there last night, and I asked town council to try to have him understand that. I'm not sure that they do understand that, but that's in fact the case.
I'm not sure I understand it either.
It's not going to have any impact on the way we.
Okay. I was just concerned, since we really encourage sewers, that somehow we'd be forcing people or potentially putting in septic systems in some place where someone wanted to put in a sewer.
No.
That's not going to happen.
Well,
Especially not if you're already in the, if you're in the sewer district. Is
Okay.
yeah.
Thank you.
It would be an issue if
Right.
you're outside the district trying to.
Right.
like
You gotta
private
come to town
sewer
meeting
lines.
anyways, and it's a process.
So,
Okay. Thank you.
Okay, public hearing on the tobacco.
Yes, so there are a number of regulations that we want to take a look at. The tobacco one was the one that was brought up to us by the tobacco enforcement officer that we get from Barnstable County. So the state of Massachusetts adopted a law that raises the age of tobacco sales to the age of 21. However, they're looking to do that implement it in a stepwise fashion. So starting January 1st, it'll raise up to 19. And then January 1st after that, it raises up to 20. And then January 1st after that, it raises up to 21. So every single year, new signage has to be printed to update that law. So the suggestion was made to us that before January 1st, if we were to update our own regulation before that law comes into effect, if we were to update our own regulation, raising the age to 21, we don't have to worry about that step implementation. It does make the enforcement a lot easier, but it's a big jump that we have to do. So we would have to schedule that hearing if the board would.
Yeah.
was there a reason for the tiered approach?
It's just the way the law, the state legislators wrote it.
I know, but you know why? Was there some programmatic intent that they thought that was a good reason to do it, or was that just a political negotiation? Or
It was more a political negotiation than anything else. They wanted to make it easier for the larger communities like Boston, Worcester, Springfield, where they have a large amount of tobacco retailers, and they have a lot of funding to reprint these sorts of things every year. Whereas in our case, we all throw into a small pot, and then that enforcement officer does all of Barnstable County and the 2 islands.
So are we obligated to automatically raise it to 18? Or do we have,
No matter what, we're going to raise it to 21 by 2021.
But if we do it before,
we have no choice?
We have no choice to go up to 21 by 2021. But if we do it now, it makes the implementation that much easier.
I guess, from a public health standpoint, to me, if tobacco products were outlawed, that would be great. But from I guess I have a concern. I mean, it sounds like because we don't want to reprint signs, we'd like to go to 21 right away. Maybe I misunderstood that. And I just have a concern about being a little different from the state, unless we have some other reason to do it besides we don't want to have to print signs every year. Like it's not good for your health or something.
Yeah, and It makes total sense. That was really the reason we were given the state of in the state of Massachusetts. I think something like 130 of the towns, approximately close to half, have already. About 40% of the towns have already gone to 21.
Oh, okay.
Yeah, we did discuss this
We did.
about 3 years ago. We redid some of our regulations, and we thought we'd think about 21, but maybe it's time to think about it.
Yeah.
And have a public hearing and vent it to the public and do what we need to do.
It would literally be the only change. 18 to 21.
Knowing that other towns have done it.
By next meeting? Or?
I suggest we can do it. We can do the hearings in December because there are a couple other regulations that we would like to look into. One of them would be the fee schedule. It's about time that we raise the fees again. It's been 3 years since we've raised the fees and specific fees, and then before then, the last time we had raised fees was in 1992. So it would be about time that we raise those. And then we also kind of want to take a look at the Nantucket regulation because we still haven't received back the peer review and the study of the landfill and what it's affecting on the groundwater there. So until we get that information back, we want to talk about maybe pushing it back a little bit because of the sewer vote, impossible sewer vote. So the suggestion that we have for this hearing would be Thursday, December 13th, because I will be out of town from December 14th to the 26th. And the next Thursday after that would be December 21st anyway.
What's the date? Because there's the third Thursday I won't be here. It doesn't matter.
Yeah, the third
I would
Thursday.
like to be here for the Nantucket discussion because I have
Absolutely.
some very, I have some hard opinions about
Yes.
that.
Absolutely. So I was wondering.
But if you don't have to schedule it around me.
Yeah. Well, I was hoping to schedule the hearings on December 13th, which is the second Thursday of December.
Yeah, because right. So you'll.
Yeah, because I will be gone, and if you're gone as well, and then I would like the whole board to be there as well.
This would be the 13th, the second.
would be the second Thursday.
I have another conflict, but this would trump it.
Okay.
That's good for me. You want to book it?
Should we?
Yeah, that's fine with me.
So we'll schedule the hearing for the and I'll get out the three specific regulations. We want to look at Nantucket, which is regulation 54. 54 is the 1 to 10,000. It's 67, I believe it is. The tobacco regulation and the fee schedule for December 13th.
Anything else? No, any questions? Okay. Okay, next, 28 Long Pond.
Okay. So I'll actually let the applicant give their information since they're here. It should be on, yes. Okay. Yeah.
Okay, thank you. Paul Santos with Nantucket Surveyors and Bill Hunter, attorney for the applicant, which is also the current property owner of 28 Long Pond Drive, Peter and Anne Marie Tallis, a family that has had a long standing ownership and association with Nantucket itself. So while this home is new to the Tallises, they have lived in the Nantucket area for some time and summered there. So the application before you is a variance request pursuant to local regulation 64.04B1, which limits flow within the Nantucket Harbor Watershed Protection District to 1 bedroom per 10,000 square feet of land area. This is a subject parcel that was created by an approval required subdivision in 1983. The lot area itself is approximately 57,673 square feet. And there is currently a 5-bedroom system on the lot, and also an on-site well services the subject property. It's located within the Zone A of the Nantucket Harbor Watershed Protection District. The property is, as many of you know, Long Pond Drive is essentially a subdivision that borders Long Pond. It's located south of Nantucket Road and is not directly adjacent to Nantucket Harbor itself. The town's HWH groundwater flow direction maps indicate, for what they're worth, the groundwater flow in this particular area from this particular lot is southerly to Long Pond. The groundwater flow from the site is southerly to Long Pond as opposed to northerly to Nantucket Harbor or the Hither Creek area. The lot itself is outside of any state-designated nitrogen-sensitive areas, interim wellhead protection areas, department-approved Zone 2s, or any nitrogen-sensitive embayments. This variance is strictly a local variance under your local regulation 64.04B1. So absent of the town's local regulation, this is a lot that would be eligible to place an IA system on the subject property and then ultimately have a bedroom credit. Now, as many of you know, the bedroom credit applies for the IA system. It gives you the ability to go essentially, when you look at it from an acre component, under a conventional system, you would have 4 bedrooms per acre. When you add the IA component under the state regulation, you're allowed to go to 6 bedrooms essentially per acre. So the lot area that you currently have for this parcel, 57,673, with an IA component under the state regulation would allow you to get 8 bedrooms on this particular lot. The state's numbers with regard to the IA reduction in nitrate effluent is essentially a conventional system influent from from a conventional system is about 35 milligrams per liter. That's the amount of nitrates that come out of a conventional septic system. An IA system, and there are different levels of IA system. What we'd be proposing in this particular case would be the microfast. The microfast has a certification under the state and a state approval for a reduction to 19 milligrams per liter. So it's a little less than 50% when you are using the IA technology. And in this case, the microfast technology takes you from a conventional 35 with the IA component, drops you down to 19 milligrams per liter. So in effect, you would be, by putting an IA system on this lot, a conventional 5-bedroom system on the lot would still have more nitrogen impact or effluent impacts than it would by putting the IA system on the lot. Putting an IA on this particular lot for an 8-bedroom system would still yield a 13% reduction in the nitrate load on this particular property. Now that's a percentage that changes by bedroom. So 8 bedrooms would be a 13%. As you drop each bedroom, the percentage would increase of the amount of nitrate reduction that you would have for the particular lot. The reason we're before you is the house has recently been sold. The system was essentially a technical failure because of groundwater separation. We have a 4-foot groundwater separation in Nantucket that now requires a 6-foot groundwater separation. It is a functioning system. It's not a hydraulic failure, but they do plan to do renovations to the existing dwelling, which will trigger under the Board of Health regulations, the new construction component. So they are bound to put in a new septic system on the subject property, which they plan to do. But what they're proposing is, in putting the new system in, adding the nitrate reduction or the IA component, but also then getting a bedroom credit for that addition. This work is anticipated to take place and permits to be pulled prior to your July 1st, 2019 deadline, I believe it is, which is the mandatory IA component for Nantucket. So if they were to go in, upgrade this system today, there's no requirement for an IA system. They would put in a conventional 5-bedroom system, do their renovations to the house, and then come next July 2019, when that regulation goes into effect, that's not retroactive. I mean, you would now have a new system on this lot that necessarily wouldn't have to be an IA until such time as in the future they decided to either try to do another renovation or something along that line. So essentially what we're asking for is the willingness to put the IA system in the ground now. The town gets the benefit of the IA with the standard reductions, It's a lot that necessarily wouldn't be subject to the July 1st, 2019 deadline because it would have been renovated prior to that date. And then the applicant moves forward with their plans for the particular site, and the town gets the benefit of the IA component on the subject property. But we do get, obviously, the additional bedroom credit for those particular, for this particular property. I think that's basically it. We still we'd still actually proposing to do the 6-foot groundwater separation, even with the IA. Again, with an IA, you could get the reduction to a 5-foot groundwater separation. We're still going to maintain the 6-foot groundwater separation. So we're not asking for two types of things here. We're still going to give the 6-foot groundwater separation, but adding in the IA component. And I'd be happy to answer any questions that you may have.
Any, Jim? Anybody else? Jim?
Very clear presentation.
I'd just like to,
That's the Sainsbury way.
oh, this is the
Yes.
same one? Okay, all right, okay, good. I don't have any questions.
It's pretty straightforward.
Yep.
You know, do it now, you won't be able to do it later, bedroom-wise.
Correct.
So, and you know,
And I
with
think
a
you do
net
get,
benefit of a one bedroom. You're only loading really 4 with the
correct,
the 8.
correct.
So-
Yeah, so you've basically got, like I said, the 5-bedroom conventional in the ground is going to be more nitrate load than the 8-bedroom with the IA.
Right.
And, you know, if this was a year down the road or 2 years down the road and they did the renovation, the IA was going to be mandatory.
Mandatory,
It's
right.
a little bit different situation. I mean, so this site could potentially put a 5-bedroom in the ground, could be there for 20 years, and you're never going to get the benefit of the IA. And the IA, I mean, it's a conventional IA. It's almost a 40. I mean, there's a reason you're doing it in Nantucket.
Right.
It's a 40% reduction in nitrates on a standard conventional system. So,
We get a motion to approve? Motion to approve?
Second.
All in favor?
Aye.
Aye. All set?
thank you.
I just have a comment. And this really gets back to some of the, and I know we're not the board that deals with development, but I do believe that some of the regulations on the 1 bedroom per 10,000 had some kind of quasi kind of thinking about development. And I'm just, you know, we can demonstrate how the IAs have a significantly reduction in nitrogen loading. But as technology improves, I don't know if there's a point at which the improvement or the reduction of nitrogen loading could be exhausted scientifically. But I'm just wondering is if as the efficiency of these systems increases, the ability to add bedrooms also increases.
I mean,
So as long as people can demonstrate that this is a, you know, improvement, then, you know, the sky's the limit. Is that,
Well,
is that
I mean,
true?
any-
I asked Roberto, is that?
So using the utilities to control growth, which is kind
I'm
of
just asking,
Yeah.
given the current regulations, is that true? As technology improves and the nitrogen loading of the systems improves, the amount of bedrooms goes up?
theoretically, yes.
well, I think the technology's already there, but this state, Massachusetts, very reluctant to
Accept it.
approve those technologies, whereas other states, Connecticut, Maine, maybe Rhode Island,
Yeah.
because with well and septic, then it makes marginal land buildable. I mean, they have systems that can treat, and you can just run it through your irrigation and spray it on your lawn. Okay, next. 13 Sainsbury.
So I'll let Jeff.
Jeff?
Excuse me. Hi, Jeff Blackwell for the applicants, which is the estate of Nikki Toole and also ECMJ Nominee Trust. The two properties in question are number 11 and number 13 Sainsbury Road. They share a common boundary line, and The owners have recognized the desirability of adjusting the boundary line between the two lots to preserve the views on the house that exists at number 11 and to therefore, with the reconfiguration that's proposed, to move the house location at number 13 southerly, so there won't be a conflict. That's the whole reason for our appearance before you today. The lots were created in 1973. They've been held in separate ownership ever since. In about 1977, the house at number 11 was constructed. Number 13 remains vacant. However, under the transition rules, when Title V was changed, a 3-bedroom septic system and well was installed in 2002 for number 13. The lot configuration would maintain the same leach field for number 13. It would not change the well and septic locations for number 11. The reason that we're here requesting a variance is because this proposed lot reconfiguration would result in the requirement to move or to install a well on what was number 13 southerly into a location that doesn't conform with the down gradient and separation requirements of the 1990 health regulations, section 62. However, section 62, when it was adopted in 1990, provided for relief for pre-existing non-conforming lots. And the language in the relief section, I won't trouble you with more than I have to here, but the language states, adjustments of pre-existing lot lines shall not subject said lot to compliance with the 300-foot separation requirement on the condition that such adjustments do not create an additional buildable lot and the distance between the well and the leach facility on said lot is not diminished. So we are here with 2 lots. There will remain to be 2 lots. There's no expansion of capacity requested. The relief criteria is met by, actually in this case, we'll be able to increase the separation between the well and the septic system. And in recognition of the subsequent changes, the owners of both 11 and 13 have offered to add to their existing septic systems IA components, which will reduce nitrates beyond what is currently required. To me, this represents an application that is conforms with your relief requirements, and it also will improve the nitrate loading in that area of those lots and the neighborhood by addition of the IA systems. That's kind of the long and the short of it. If you have any questions, I'd be happy to address.
Jim, any questions?
Well, we were talking about this creates brand new lot. Is that right?
Right.
It creates lots of different configuration, yes, but in the sense that they're not new lots, in the sense that you're creating something that doesn't currently exist. I don't know if you've seen the plan, Jim. Have you?
Yeah,
Yeah, we have the
You
plans.
got the plans? Okay.
but this is all registered land court land, correct?
Yes.
So by changing the lot lines and reconfiguring, you gotta go to land court again. It's a
Yes.
different lot, right?
Yes.
Okay.
If you can look at it that way. Yes.
So if you go ahead and create a new lot, that pre-existing septic system is no longer, goes away. You're not gonna be able to use it.
Well, the lot configuration will allow the existing leach fields, septic system to be maintained in the current position.
Yeah, but you've got the system in on the lot of record right now. So when you go and change the lot line, now you gotta conform and meet Title V of today, which is one for every 10,000 square feet.
I cannot find a regulation or a section that supports that. There is nothing in Title V or the local health regulations that
Right, but
makes that
what's happening
statement.
is you're giving it, it's a new address, it's not the same lot. I get where you're coming from and what you're trying to do, but it's not the same lot, which that septic went with that lot. Now you're creating a different lot by moving the lot lines around, even though you've maintained the same square footage.
Yeah, and the same leach field that was installed in 2002 for the smaller lot.
Right, which is
will-
good for that lot right now.
Which will continue to be used. There's no requirement to replace that leach field.
Well, that's not how I see it.
Well, the view from 10,000 feet, in my opinion, is you have two buildable lots now. You're going to end up with two buildable lots of a different shape. And you're going to add IA, which will improve the reduction in nitrates. It's from strictly a Board of Health view, you've improved the situation.
But when you change that and you make this a new lot, it's not a lot of record anymore. The lot of record was the original lot.
That's correct. In your
So now this is a brand-new lot.
Well, your 1990 regulations makes specific provision for lot line adjustments.
Lot line adjustments, but you're creating a completely new lot with a new address.
It's a
And
lot
new
line
The
adjustment.
frontage is on a different, it's not even the same frontage.
It's a lot line adjustment. How is that not a lot line adjustment? We're not creating new lots. There's two lots now. There will be two lots. They'll just be in a different shape.
I don't think land court's gonna see that it's not the same lot.
Land court has no interest in Board of Health. They have no interest in where your frontage is. If the planning board signs the plan, land court it's not an approval hurdle for this proposal.
Where does the staff sit on this?
Maybe you go over Art's.
Yes.
Yeah, because I'm having a very confusing day here.
Yes. So Artel, who is unfortunately not here today, had a conversation with the DEP, specifically Brian Dudley, and they were both back and forth on this conversation about similar things. Is it a lot line adjustment? Is it a creation of a new lot? Does the previous regulations still count? Can they keep the 3-bedroom system? And the consensus that they both kind of came to was no. In general, was this septic system was built post the redesign of Title V, so post 1995, but it was built within that grace period that was given until 2000 to allow old permits to be closed out. According to Brian at DEP, the mistake that was made here was that no foundation or no connection was ever created. Had they serviced some sort of a building or some sort of a foundation, something like that connected to this septic system, we would have had no choice. But they didn't. And as a result of that, Brian is leaning more towards the denial, which in turn turns us to the denial. Which is why he's here today.
I think the difficulty that I'm having is that, I'm aware of the conversation that Artel had with Brian Dudley. They cannot provide a policy statement, or they can't cite a section of the Title V code, and nor is there any prohibition within your code. In fact, I would argue that your regulations specifically allow for situations like this. It's right in 62.06 relief. Perhaps the course would be for Artel to try to obtain from Brian Dudley the chapter and verse to support his view. There are gray areas within Title V, as there are within your regulations, but 62.06 specifically allows for this situation.
Yes, Jeff brings up a good point in that Brian does say that there's guidance, but he hasn't given it to us. So,
But we have a statement from him saying
Yeah.
that that's, I mean,
yes.
so, I mean,
No, of course. I'm just,
I mean, that's the-
I'm trying to be as transparent
no,
as
no,
possible.
but I mean, I would think that a conversation that you have with DEP is you would recommend action based on that,
Of
correct?
course. That's
Okay.
why, that's
And that's
why
what
we
you've
recommended
recommended.
it.
Okay.
That's why we recommended that.
Are we talking health issue here, or are we talking about property line issues?
I think.
'Cause,
what I'm-
am I hearing the
my
nitro-
question is, if we say this is a new lot, then it affects the septic system and what we have to do here today, right?
Yeah.
If we say it's the same lot, then he's asking for variance. But if it's a brand-new lot, what happens, my question to you now is, what happens if it is considered a brand-new lot as far as septic systems and how many bedrooms they can put in? And so if it's a new lot and it's a 12,000 square foot lot, they're only allowed one bedroom.
Right.
Is that right?
Correct.
If it's the same lot and they just move the lines, they're allowed a three-bedroom septic system, which they already have. Is that right?
Yes.
Well, I mean-
Move the lines yet. But
Right.
if they keep
Right.
it the way it is, yes, it's 3 bedrooms.
So is it up to us to say it's just moving the lines, or is it up to say it's a brand-new lot? Is there someone else that can give us that?
The only vote we have ahead of us right now is this is a specific variance to the well placement. So really what it comes down to is we are voting yes or no on the well, not necessarily on the system.
On the well for the existing lot or on the well for the new lot?
Either one, because they're looking to put in a new well on the new lot or new lot subdivision, which is what this variance is for. If it gets defined as a new lot by land court or something like that, that's a hurdle we have to talk about later. But the only vote that we have in front of us right now is the well.
Well, do we have any say? Can't they drive a well if they want? They have to come before the Board of Health to drive a well?
They don't, but right now the well doesn't meet the setback, which is what this variance is for. The front page of the application explicitly says that it's just for 62, Regulation 62, which Jeff brings up excellent point on. That is the only regulation that we're taking a vote on today. We're not making any decisions on whether we're telling them to take the system out or whether they're entitled to keep the system as it stands. If it gets declared as a new lot, then the conversations with Brian and Jeff and DEP comes in. Right now, we're just voting on this private
So
well
what are the
location.
consequences of us giving him a variance to drive the well?
The consequence for variance to drive the well, if a new lot is never created,
Yep.
this well would be on somebody else's lot, would be on the 11, would be on 11, which is owned by the same property owner, but still it's technically a different lot. So most likely you wouldn't drive the well. This is just the variance for all the setbacks. That's the only thing we have purview right now. If we were to take a vote on the septic system or anything like that, that can be a problem.
That's not the
Okay, so
question.
then all we're gonna decide today.
Is the well.
Is the well.
Is the well.
Whether or not we can
And
put
Jeff,
a well on.
correct me if I'm wrong
potentially
on any
other
of that.
property.
You're absolutely correct. And I guess what I would request the board to do is seek this policy statement that Brian Dudley seems to remember but can't produce, number one. And two, I would ask the board to further consider, the result of this is not an increase in density, increase in the number of lots. The main result in this whole thing is you're going to have two IA systems put in to reduce nitrates, whereas if the lots were not reconfigured, the two conventional systems could continue to exist and to be used as they are. I think as a board, I think I always try to think about, well, would a board think that they're creating a precedent? I mean, this is such a narrow, unique case that if it is a precedent, I would think it's one that you would want to approve on the lot reconfiguration, which is down the road, because it provides a greater degree of public health and safety with the IA systems.
Well, I don't think we have the ability to tell them it's an existing lot or a new lot.
Correct.
I'm ready to vote if we want to give him a variance to drive a well, let him drive a well.
It's the same conversation actually in the comment that Jim, you made after this previous thing, this previous variance. When we start discussing lot lines and buildable lots, things like that, we're overstepping the bounds of the Board of Health and entering that of zoning and planning.
I don't think we have the
Yeah,
ability to tell them it's
Well, you could make some argument that density and zoning all has a public health implication.
They do, but until we know.
How I can make that more specific than a philosophical discussion, I
Right,
have
I
to agree
understand that,
with you.
But we don't know if it's going to be a new lot. We don't know if it's going to be an existing lot.
correct.
Who makes that decision?
Land court.
Okay.
It's not our choice.
So would one option for you to go to land court and get this settled and come back to us?
It isn't a land court matter. I mean, the next appearance of these properties before the health department would be the presentation of two new design plans for the reconfigured lots with IA systems added. That would be the permit application that would follow. It's not before you today.
I'm not talking about to the Board of Health. I'm just talking about other, because I heard Steve say that you need to go to the land court. This is a land court matter.
Well, ultimately,
Eventually, but I go back
the
to
well
Jim.
thing now. So
We're really just talking about this well.
Yeah.
And
But the question was, if somebody decides that it is or isn't a lot,
If we
we
make-
might make a different decision, is what
If
I
we
heard.
make a decision to let him think that it's going to be just moving lines,
Right.
okay, and start to follow through, and it goes to land court, and land court says, oh, no, it's a brand new lot.
Yeah. And then
Then
what?
we have to start all over again, right?
That triggers
we've
the
already-
enforcement through Title V.
Right.
That's a different
so that would
enforcement.
come down. That would be later.
it'll be later.
that's
So-
later when you're presented with new septic system
Yeah.
design
Or
plans.
somebody's trying to build a house or
Exactly.
Right.
Yeah, that's
pull a permit.
that's not the issue.
No, the issue is well.
It's simple.
So the variance is to
It's to drive a well.
issue a permit to dig a well for house number 1 on house number 2's lot.
It'll be on house number 1's lot if
I don't
the
think we
loo.
should, I don't think we should say that.
I'm just trying to. I'm
Yeah,
not
I
saying
know.
we'd say that.
Okay.
Yeah.
But I'm just.
We're just
you know,
giving permission
Can you
to
maybe
drive another
explain
well.
that again,
Yeah.
Jeff?
It's
Well-
the same. It's the same owner too. So
Yeah.
It's the down gradient
Yeah.
thing.
Well, the relief that's requested is for, once again, I'll read this quickly. Adjustment of pre-existing lot lines shall not subject said lot to compliance with the well regulations, the 300-foot down gradient separation, on the condition that such adjustments do not create an additional buildable lot, and the distance between the well and the leach facility is not diminished. We satisfy those criteria. Inherent in the variance is, I think, has to be some recognition that your regulations allow for the adjustment of property lines on lots of record, lots that existed prior to 1990.
It's actually simpler than we've made it.
I think my own view of this is, if we let him drive the well, right? And they go to land court, and they say it's just what he says it is, then he's ahead of the game because the well's already in the ground. Okay? And he's gonna have to come back to us anyway.
Ultimately, yes. But ultimately, what it really comes down to as well is both lots are owned by the same person.
Yeah.
They can drill this well on their own lot.
They can build 5 wells on
not-
any lot they want.
Exactly.
So this is
This is a setback
I tend to
variance.
overthink things, and I'm not sure I'll ever understand it. But I guess I'm
I'm
you know,
with
and
you.
I'm not a lawyer. But it's back to our nitrogen loading, and I know we're not supposed to talk about septic systems, but I don't think it's a bad. It may not fit the letter of the law, but I don't think it's a bad thing. So I'm going to make a motion to approve the variance.
Second.
All in favor?
Aye.
Aye. I mean, down the road, what'll really happen is when somebody comes to pull a permit for maybe building on that lot, then maybe
We'll
we
deal with
could
that.
get that, address those issues, whether you gotta meet today's code or grandfathered with that septic now.
And it's the same owner. It's his land.
Well, these are held in different ownerships.
Yeah,
These
they're
are not the same owner. This
Okay.
is the estate of Nicky Toole and a different trust, which is
Okay,
noted
okay.
ECMJ.
But
But if we
But
could
in the
get some
meantime, I would hope
clarification.
that we could solicit
Yes.
further guidance from Title V.
yes, we need to get that guidance document. You're absolutely right.
Thank you.
Yeah. Okay.
Next is the septic loan.
Okay, yes. Loan request, 22 Sasapana.
It's a IA system from Mr. Costa. Straightforward. We have no objections. He's trying to comply.
Wait,
question?
is there an attachment in terms of what the real request is?
Yes.
The breakdown?
Yes, the breakdown should be on the. Oh, is that the one that was corrupted?
I didn't see it. So.
Yeah, there's little blue bars.
There's one of them that can't. Okay, so now it's loading.
Oh, okay.
So there was one file that ended up getting corrupted for a
Okay,
while.
it's down- here we go.
So there you go.
Okay. Thank you. I didn't see that.
So the one that we've always been worried about, the landscaping and things like that, and my computer just died, ran out of battery. The landscaping was always what we were worried about. In this case, Bobby said that he did it almost all himself, so it only came out to around like 5% of the loan. I don't have it in front of me anymore because it
$786.
exactly.
So I make a motion we approve the loan request.
Second that.
All in favor?
Aye.
Aye. Update?
Yes, so we have an up. I put on the agenda here because we have talked about it before about if specific board members have something to be brought up, kind of like the select board does with their committee reports at the end. if there's anything you want me to look up or to have for the next Board of Health meeting, this Board of Health update would be perfect time. So this is for you five.
Anybody,
Anything?
you got something you need
I have
to?
one thing.
Jim?
So at the last meeting, we talked about, this is on the marijuana regulation and the testing of marijuana and the fact that it's going to be on-site, not off-site, and the questions we had about the validity of that or what the technical, scientific terms for that. I spoke to Dr. Dylan Fernandez's office, and they're willing to put together a meeting with folks from our board and the head of the Cannabis Control Commission in Boston to lay out our concerns. And if you're interested in doing that, I'll follow up with them. And
Oh,
they
please
said
do.
it would be probably in, because I think he carries more weight, Julian's office. But I could do that. And I've also talked to Roberto to find out what Martha's Vineyard's doing. Obviously, from a political standpoint, if two boards of health come together, then I find out they have 5 boards of health.
Yes.
So,
They have trouble coordinating.
and then talking to the town manager today, just about there's a lot of variation in the way that they're addressing the marijuana licensing issues by town. So I don't know if that's, but anyway.
I have a couple of things. Going back to what you said about putting septic systems in, and we were talking about the sewer. Where are we with Nantucket?
So that's
I mean, are we way out?
it sounds to be further out than we first expected.
All right, so before you go any more, what is that going to do as far as our regulations with people in Nantucket?
So that's actually why I wanted to set up the public hearing. So right now, our regulation will mirror the Nantucket Harbor watershed starting July 1st of 2019, which is this coming July. The original thought was sewer would be back on the docket for annual town meeting this coming April. The process for getting the information from what is the issues with the landfill and the groundwater and everything, we were supposed to get that information back already, which we still have not received. And we're hearing that it's going to be closer to the end of this year, December. So at which point the warrant for town meeting will be closed. So what we're suggesting is push back the implementation of the Nantucket one regulation, but that is topic of the hearing. If the board believes we shouldn't push it back, we won't push it back. The only thing that have to be a little weary of when it comes to that regulation is when you put in the IA, they automatically get the 10-year variance. And the more IAs we start pushing people to get in Nantucket, the less likely a sewer vote would pass.
Is there a reason for the delay in getting the information?
Honestly, I don't know what the reason was. I know the process started late from when we originally got the funding to do the study, between the transfer of the previous DPW director to the new DPW director and then the loss of the deputy director. That process ended up slowing down. But we just heard back from SMAS that it's taking longer than usual, was what they said.
We wanted
So-
the wells that were missing. We needed more data from them that were put in last January.
So are we looking at like 5 years?
No, I wouldn't
I'm
say
talking about
that.
till the actual sewers start going into the ground.
So if we were to put it on the agenda and then
Yeah.
vote it in, and
And go out and get prices and get bids and get this and la-di-da.
it's hard to tell. That actually depends on if the select board decides to put it on the agenda for a town meeting.
It's not on the near horizon.
Okay, so then let's say it's 3 or 4 years. So in the meantime, are we going to change the way we handle Nantucket as far as sewer, septics are concerned? Or are we going to, what are we going to do?
it's going to change in July.
That's as of right now. It changes in July. Starting July 1st, every new construction, property transfer,
Everything.
anything,
Everything.
just like the harbor watershed,
Okay.
the Nantucket Harbor watershed.
Yeah.
So
So then everyone that puts an IA out there, automatic will be filled with IAs, and they won't have to tie into the sewer for 10 years.
for 10 years.
Yeah, from the permit.
Which is not actually a good idea.
No.
It's not a good idea if you want to get sewer everywhere.
Well, go wait for the hearing.
Yeah.
Really, I'm stopping to think of it. 10 years.
I mean, but you could project the number of IAs that would be installed based on property transfers and new construction over the last 5 years.
Yeah,
That's an excellent
You
point.
could look going forward.
And then you
It's
could
not gonna-
multiply, even though it's reducing the nitrogen, you can multiply by the amount of nitrogen being released
Yeah.
versus what a sewer would be. And,
Right.
you go right back to the need for sewers. But then you have, anyways.
Yeah.
Yeah, I
Well, let me ask you another
I mean,
question.
it could
Why-
change with the different
Are we
boards.
looking for the people in Nantucket themselves to vote yes at the town meeting? Is that what we're doing?
No, it's not necessarily to put a political pressure. That's not it at all. It's literally the protection of the groundwater. The groundwater is rising in Nantucket. So a lot of the systems, as they go in to do inspections, are starting to technically fail based on groundwater separation. So as a result, if they have that technical failure, they're going to have to put in an IA. But when they put in the IA, they now have to mound the system. So not only are we asking them to redo the IA system, we're asking them to bring in what you'll hear called Title V sand, which is the sand that's
Special
gone,
sand.
which is extra sand, which has to be shipped in from off island. So all of a sudden, a IA system that on Sisapana Road only cost $26,000. Because it was just a component replacement. In Nantucket, you have to bring in sand and install new trenches and do the whole thing. You turn a $40,000 system into a $140,000 system, which
That's a little extreme.
and exactly. So that's
So our options are there to delay the implementation of that regulation?
The
Yes.
bottom line is that we're waiting to rerun the model which we'll have hopefully by December.
yes.
And then some decisions can be made.
I would think Nantucket would be a great priority.
From a capital perspective or from, I mean, I'm asking,
And my other concern, I was going to ask you what's going on with the landfill?
We
It's a good question.
The group hasn't
we
met.
haven't met in a while, and some things, set everybody back with the sewer break, all that.
I didn't even factor that in.
I would think we're probably going to meet at some point pretty soon.
Yeah, I'm putting it in my calendar right now to
Yeah.
follow up with DPW, see where we go.
Yeah.
and what is that, what are you referring to? Is that a
Just the
work
the
work group or
landfill
something?
and its impact on Long Pond
Oh, okay,
and all that.
okay,
And that's
okay, all right.
information is being collected now.
Okay.
And they wanted to wait to get a few months worth of the new wells, which was directly down gradient.
Oh, right. Yeah.
And those have been in since January, and I think Brian was going to get all the new information and all the well information and everything else, and then rerun the whole estuaries model with
Okay.
all the new data, the number of IAs that are in the ground out there now, the same thing, the total build out, and figure out what the impact of the landfill with the real data is actually doing to Long Pond and Hither Creek. So that information is very pertinent to some of the decisions that are going to be made.
Yeah.
Exactly. The previous criticism that we had received from all the models was that it used an analog.
Yeah.
It used, I believe, the Auburn landfill
It was,
or
Brewster's
landfill as the analog. Now we have site-specific data, and that site-specific data will be run through that model. We just haven't heard back.
I mean, you all know better than it's a political process in terms of getting the sewer out to Nantucket. And there was a lot of political. I mean, the whole harbor, save the harbor. I mean, that appealed to everyone on the island. When you identify, and when you identify a certain population like Nantucket, people are going to say, how is that going to affect me? I mean, everybody uses the harbor, whether that was true, whether, you know, so I'm just telling you, and you know, I'm just, so you all know. So
Yeah.
Okay. I'm good.
Anything else?
I like the way the update line item worked.
yeah, it was nice
It worked well.
If that's the case, motion to adjourn? So moved. Okay, we're good.
All
Done.
right. Thanks for tuning in.